of this show, bite-sized tips for busy entrepreneurs. Oh my gosh, how cool was my new intro video? I'm back here rocking out. I'm like, yeah, I like that. It's getting me all ready for this show, which is going to be amazing. Hi, everyone. I'm Mary Thane Brent, and this is Bite-Sized Tips for Busy Entrepreneurs. This is going to be a hot, fast, fun, informative show. You're going to want to grab your laptop, some coffee, your notepad, whatever you need, because my guest, Sam, is friggin' amazing. He's going to save you lots of headaches and a lot of money. I know that's weird when you say attorney is going to save you money, but he is. It's time to make sure that you've got your assets covered. I just like saying that word. You're busy running your business. You're gaining traction. Your business is growing, and bam, someone steals your logo, your content, or copies one of your contracts. Maybe they demanded a refund for a service that you provided. Your time is now sucked up with legal stuff, which is not your cup of tea. That's not where your brilliance is. Let me tell you guys, this happened to me a few years ago. True story. We're going to talk about it a little bit with Sam when he comes on, but someone basically took my teal LinkedIn cupcake, my LinkedIn bakery cupcake. It's in teal, it's signature, everybody knows it, right? I worked on building my brand so hard, and that cupcake, not only was it my brand, it was my mission and my story, because the LinkedIn bakery, that was born out of honoring my mom, because she was this amazing baker, and she's why I started my business. So it broke my heart when someone copied that cupcake. They just took the word LinkedIn out and threw in a different word. They also copied my website, like the LinkedIn bakery. They did a blank bakery. I'm not going to say because I don't want to call that person out. We've already had words and I already had another attorney involved. So I want to make sure that you guys are protected and covering your assets. So I've asked my friend and my personal attorney, Sam, to join us. We're going to be talking about contracts, why you need them, and why you need them to be legalized. Legalized? Is that the right word? Sam's going to come on and correct me for all the stuff I say incorrectly. We're going to talk about copyrights, what you can and can't copyright, and we're going to dive into a little bit more about my story and content. Now, I hadn't thought about content. How do you protect your content? Oh my God, this show is going to be amazing. I want to know where you guys are watching from. So in the comments, you guys, just drop where you're watching from and what industry you're in, because I love connecting people with other people. And I know a lot of people, and they're always looking for service-based people, sales and speaking coaches, things like that. So let me know what you specialize in. And before we get started, how fun was that intro video, right? Can I get some high fives, some hearts, some thumbs up? So I'm using StreamYard to go live on 3 different platforms, 5 different profiles. It's so easy. This girl can do it. You just hit the go live button. I'm going to share a presentation. I'm going to have a guest on. We're going to have questions. It's that easy that I can do it. So I know you can too. So if you're looking to up your live streaming game, I'm going to drop my link over in the comments and you can check out StreamYard and you can get started streaming or time to level up your streaming game. So you know what? Enough about all that. Let's get Sam on the show. Sam.
Hello. How are you?
I am fabulous. Oh, I forgot to tell everybody. Happy Cinco de Mayo.
Yeah, I've got a fun shirt on. I think that's all I'm bringing to the party, though.
I'm not drinking while going live because everybody recommends not to do that. And I have to drive somewhere later. But happy Cinco de Mayo. This is going to be a fun and informative show. And I just wanted some props in the back.
Great props.
So, yeah. So, Sam, why don't you, I know how great you are. And there's a lot of people like Stephanie, Lou, and Kendra, and was it Amy? When we started promoting it, people are like, oh, Sam's my attorney. Sam's great. I was like, look at that. Sam knows everybody. I love it. So why don't you tell us, I'd like to know, or the audience to know, how you got started and what this passion is for working with the entrepreneurs and small business community.
Yeah, absolutely. I mean, I think I should start with the fact that I'm jealous of your intro video because it is rad, and I was over here grooving to it as well. So definitely into that. But yeah, so our intro video less law firm is called Better, and we serve nonprofits, small businesses, social enterprises, and then like freelancers, solopreneurs. And really what we do is, it's easier to say who we serve because we do so much. We are essentially what you would consider a general practice. And the reason that we're a general practice and we can provide such sort of robust services is kind of to the point of your question, sort of due to my professional trajectory, I guess I would put it, because I actually started, obviously went to law school, started at a law firm that was interesting. I'm going to just use that word. They weren't the best characters. And I did learn a lot there. You know, I learned about collections and contracts and court and business setups and all kinds of things. But then I left there and actually was a volunteer at a nonprofit organization here in San Diego called Invisible Children. I was there for about 1.5 years, and then the general counsel there joined me, and we started our last law firm, which was called 𝔹𝕀𝔾 ℚ'𝕤. And then just right at the start of the pandemic, March 1st, 2020, I launched Better. And really, Better is kind of a doubling down on the things that I thought were the best about my last law firm, which are going to be education, number one, for all of our clients. I see my role, and really the role of attorneys, is to give you the education, give you the tools, and equip you with that knowledge to empower you really to make the decisions for yourself. And then we try to leverage technology so we can meet you where you're at, make it easy, make it accessible. A lot of those buckets of clientele I mentioned typically aren't really able to access legal, and maybe they're priced out or just traditionally underserved by legal. So it's a big priority for us to serve those folks and make it affordable, approachable, and accessible. And yeah, I mean, with that, you know, I'll give another plug to StreamYard. This is my 2nd or 3rd gig I've done on StreamYard, and it's always been great.
I love StreamYard. I was just on their show on Monday, and it got a lot of great feedback. And I love Julie, Gage. I just love the whole team there. What they have created is amazing, and it's getting better every week. That, you know, first off, they listen to us. You know, so if you're in the StreamYard community, they listen to us of what we think we need, what we think would be helpful, and then they act on it. They don't just like ask, hey, what would you like? They're like, hey, that's, you know what, we're getting a lot of feedback on that. They're going to go in and create that if they can. So
Amazing.
Shout out to StreamYard, the official sponsor of Bite-Sized Tips for Busy Entrepreneurs. Sam, so you're in San Diego, which is still my hometown. Like, I know I don't live there anymore, but still in my heart. How's the weather there today?
It's actually great today. And I think you're in my hometown, even though I'm in your hometown, because you're in Phoenix, right?
Well, I'm in Arizona. I'm actually in Surprise.
Okay.
Surprise! I'm in Surprise, Arizona. I am going to Phoenix to pick up a friend who's flying in tonight.
Nice.
So.
Yeah, that's my hometown. So I've been here now in San Diego for about 12, maybe 13 years.
Wow. So how does it compare to Phoenix?
I have no plans to move back to Phoenix. We'll put it that way.
I know. I love San Diego. San Diego will always have a place in my heart. I want to give a shout out. We've got Brian joining us. Vamp Boss founder said, happy Cinco de Mayo. Thank you for picking up on that. Melissa sounds fabulous. I'm about to launch my website, so this will be good. Oh, Melissa. Yeah, you're going to want to take notes, girl. We have Selena who says, love StreamYard, waiting super patiently for the LinkedIn Live approval. You and 400 million people. So it'll come. Selena, don't give up. You'll get access. A little birdie told me earlier this year that everyone's going to have access to it by the end of the year. So we all know, side note, we all know that'll take longer. It'll be next year. But, right? So don't give up. So Sam, you know, thank you for joining me. I appreciate your time. Should we start kind of with my story? Because I reached out to you and you were going to tell me, you know, you had looked at my old website and you were going to say, right? You're going to do that. Oh, you shouldn't have. And I told you my story about how basically the LinkedIn bakery, you guys, I can't copyright that. Nothing I can do about it. Why? Because it has the word LinkedIn in it.
Yeah. So the one thing that, you know, people always kind of find surprising about copyright, trademark, all these different types of intellectual property laws, that they're not as straightforward as you might think they are. You know, in that particular example, having LinkedIn in it, you know, you would have thought, look, I had this created, I had it designed, it was inspired. You know, you told the story at the intro, so it's yours. It should be something that you can protect, you can register. But with trademark, you know, and logos and brand names and things like that, really difficult actually, because there's so many nuanced rules that go into it. One of which is the one that you touched on of you can't use usually somebody else's registered trademark in your own trademark, which LinkedIn would be the trademark in this example. And there's a myriad other rules that go along with trademark. We'll touch on some of those in here today. And I was actually going to say, Mary, if you want to do the disclaimer slide so I can just get that out of the way.
So we do have an attorney on, so let me get that up for you.
Just get that lawyerly duty out of the way.
There we go. Let's lawyer up.
Yeah, I'm not going to read this verbatim, that's for sure. But essentially the gist of this disclaimer here is that anything that I say today, obviously anybody that's watching this, I don't know your specific facts and circumstances. And so I'm not providing direct legal advice to you. And so please don't go out and act on anything that I talk about or recommend in this today, because you need to have an attorney advise you on your specific circumstances and particulars. And so this is not legal advice. There's no attorney-client relationship from this. Mary and I have one, but what we're going to share is outside of that. And so, yeah, the disclaimer is please don't act on any of this stuff. We offer free consultations if you need to talk it out, and many attorneys do, even if it's not us. So make sure you talk to an attorney if you hear anything in here that you think might be helpful to you.
Yes, thank you, Sam, for reminding me to put that up. And you guys, you know, this is just an overview of why you need an attorney for these three areas of your business. This is not legal advice. So thank you, Sam. And you guys, I just want to give a shout out to Sam because I think he's the attorney for all us small business owners and entrepreneurs in particular. And I'm going to tell you why, because you talk to me like a regular person and I can explain why I need your services, why I need to protect myself, and how much it's going to cost me. Like, there's no hidden fees. You know, I've heard horror stories of hidden fees with some attorneys. And basically, you know, you walked me through everything. And I love that. I definitely need to give you a testimonial. Remind me about that later. So what do you want to start on? I know, should we bring up your cute,
I mean, I love his stupid little face, so we should probably show everyone.
I know. So I just have to find it over here. Okay, here we go. And it's so appropriate. I love that you made this. Why do I have quills? To help me protect my assets. And why do I have a margarita? Because it's Cinco de Mayo and I'm of legal age. So we just wanted to share something fun with you before we get into all the information. I love this slide. Thanks for making that.
Yeah, I mean, shout out to my associate attorney and partner here at Better named Olivia. She does all of our graphics and sort of like branding and messaging and comms, and she's a wizard at it. And in addition to that, she's got that cute little pup that's in my little thought bubble there. That's actually her dog, Louie. So also a big plus with having her at the law firm. And in addition to all that, the probably most important aspect of the fact that she's a part of the law firm is she's a wizard when it comes to labor law, employment law, all of everything that goes into that. You can see there she's got what's called a Society of Human Resources Management certification. And so she's just great with everything like that. Also helps with privacy policies, terms of service for websites, contracts, different things like that. So she's not only great with all those, but she is also great at making our little hedgehog mascot, Birdie, look pretty cool and make him timely for holidays.
I love it. I love it. So Sam, where do you want to dig in? What do you want to start with first?
We could probably just do, yeah, I mean, if you want to just run through the slides, I can give everyone kind of like the basic definitions and the foundation, and then we can kind of just talk through some stuff.
Should we start with?
Sure. So, you know, one of the things that I think are most likely going to be relevant for everyone on this are going to be copyright, trademark, and then confidential information and practices. You know, maybe another thing that kind of plugs into these is going to be just any content at all. So for instance, you know, if let's say Mary had a contract to do something like this with someone else and it was on their platform and there was no contract in place sort of dictating how that's going to be used, how it's going to be recorded and all of that, she might end up seeing that recording all over the place. And that's certainly not an example of it being protected and being used in the way that she would want it to. And so maybe that's like a fourth subcategory that fits in there somewhere. But we can move on to, I'll give you guys the definitions of some of these different types of intellectual property. So yeah, how do you protect these things? So how do you protect your assets? That's the topic, right? And there's a number of different ways, and they're really going to be pretty like situation specific. So you can see down there, you know, I'm going to say contracts just across the board, having an agreement in place. And there's just so many versions of that and so many places where you can use that. And so you'll see in the yellow there, you know, a master services agreement with your clients. We sometimes call that a client services agreement. That's something that should cover literally everything and anything that you do. Maybe you'll attach a scope of work to it for the details for each client engagement. Independent contractor agreement, vendor agreements for third parties that you work with that aren't a part of your company. I mentioned the privacy policy terms of service. Those are going to be really important for on your website, for on an app. And especially nowadays, if you're in California, we have pretty much the strongest data protection and privacy laws in the country. And they're somewhat mirrored after the strongest ones in the world, which are in the EU. And so definitely want to update those if you haven't in a little while, or have them if you don't have them. Waivers, releases, especially during COVID, it's going to be sort of like the age of the waiver, I think, what we're going into here with events and things like that, because everyone's going to be trying to say, look, if you get COVID or if something happens, it's not our fault. Waivers and releases are great for that. And then, you know, purchase terms for online sales. A lot of the time we call that a click wrap agreement, where, you know, you go to purchase and there's a little, I read this and I agree to the terms, even though you didn't read it and probably don't know what the terms are. That's a good contract to have, because even if people don't read it, once they check that box, they've agreed to it. So those are some of the ways to protect your content. And then I'll talk a little bit about the types of content so that we have that framework going into the conversation. So copyright. Copyright's a big one. You know, copyright would cover this recording. It would cover, you know, any type of written content on your website. And then, all these examples here are good ones too. And I always use the Harry Potter example for some reason. I guess it's because I've watched all the movies a few times and have gone to Universal. But the interesting thing about copyright is, all of these things here, when she thought up Harry Potter and Hogwarts, when you think of a photograph or you aim it in your camera, when you write the film script, until you actually write it or snap the photo or put it down on paper or some version of, fixed medium, it's not protectable. When it's just an idea, you can't protect it. And this is actually a really important thing when you're pitching. So if anybody out there, watching this, they have to pitch things on behalf of their business. If you're pitching it verbally and it's not written down yet, it's not in its final form, people might steal that, and they might be allowed to steal that depending on what agreements you have in place. Another place for a good agreement is this, having a confidentiality agreement. If you're going to pitch to someone, that would be a good thing for you to have. And then, if we want to move over to the next one, I think the next one will probably be trademarks. Yeah, so trademarks is what we were talking a little bit about at the beginning of this, which is going to be a logo, a brand name. These ones here are.
I'm sorry, I'm reading the slide. You can trademark a smell.
Yeah.
Get the front door. Did anybody know that you could trademark a smell? Can you trademark a taste?
I don't think so. Why wouldn't you be able to if you can trademark a smell, right?
That's amazing. I had no idea you could trademark a smell. So you can actually trademark a lot of different things.
Totally. The thing that comes to mind for the smells, I guess I shouldn't have put you, because the one that comes to mind is Chanel No. 5. I'm pretty sure they have that scent trademarked. And things like that. Another example of something that you might not think can be trademarked but can is essentially trade dress, they call it, but it's packaging. So the Coca-Cola bottle shape, that's trademarked for Coca-Cola. You can't make a drink in that bottle shape because it's theirs for beverages.
That I had no idea. I just thought it was a soda bottle.
Right.
But it's a Coca-Cola bottle.
Exactly. A trademark registered in all 50 states, Coca-Cola. And they probably have it registered across the world, actually. But yeah.
Yeah, they're probably internationally trademarked.
And a quick, I was going to say a quick clarification on this, because Nike's a great example. I always use them because they have so much different merchandise out there, so it provides a good example. So if you're, thinking of a Nike shirt where the swoosh is just, like right here on the breast, small, that's a great example of trademark usage because it's small, it's not the predominant aspect of the clothing, and it's used as a source identifier, as you see here on the slide. But if there's a Nike shirt where the whole shirt is the swoosh, that's not actually a trademark usage of a trademark. That's just a graphical representation on the shirt. And so for the purposes of trademark, if all of the Nike merchandise had the huge swoosh on it, they actually wouldn't be able to register that as a trademark because that's not a trademark usage. So all those shirts where it's on the sleeve or, right here on the breast and really small, that's what allows them to use it as a trademark on merchandise.
Wow. Okay. Okay. So in the comments, there's a lot of comments going on. Colleen, what did you just learn a few weeks ago? I think she said something about you can.
Maybe it's the smell.
The smell. Right? That's crazy, crazy, crazy. Do you know Melissa?
I don't think so. The name seems
or Colleen. Familiar. Do you know Colleen Marche?
I don't think so.
Well, hello, ladies. We're glad that you're here. I didn't know if it was someone that you knew, someone that I knew, maybe in my group. So yeah, you can. Okay, how is the Empire State? How can a physical building be trademarked?
Yeah, so that one's a good one too, and that's actually one that I've been working on lately for a client. We have a client that essentially creates like digital worlds, and so in those worlds, they recreate real world things. And so one of the ones that I've been sort of looking at for them is they're doing different sort of places around the country and the world. And in doing so, we want to make sure that they're not going to release that and then get sued for something in there that's protected. And so one of the things, through this research that we've been able to determine is protected is the Empire State Building. And it's an interesting way that it's protected because it's not necessarily the words Empire State Building. It's not necessarily, it's not any specific pieces of it. It's sort of like what the building looks like in the skyline is what they've sought to protect. And so it's
Really?
one of these things where it's even kind of hard to explain the concept because it's so strange. But usually, you know, if there's such a recognizable landmark or building, that's why because it's that kind of source identifier type notion. And so for the Empire State Building, it's kind of like, I would imagine the city is who has the trademark registration. And so probably for them, it's a source identifier for New York City when you see an Empire State Building. And so I think that's kind of where they went with that one.
Interesting. So we have a question from someone in my group. David's joining us. Hi, David. Thanks so much for tuning in. And real quick, Colleen said, nice to meet you both. So we don't know her, but thank you, Colleen, for joining us. So David's question is, where do you see micro businesses, sole proprietors, find a balance between cost and benefits of protecting intellectual property and our information products? So I believe that David is a service provider, like mastermind groups and stuff. So how do, you know, I think we probably have a lot of service providers tuning in today. How do we protect our intellectual property? Like, what does that look like?
Yeah, I mean, first of all, I love micro businesses for sole proprietors. That's pretty great. But you know, there's a lot of sort of, I guess what I would say, low-hanging fruit, kind of easy things to do to protect yourself. And then there's sort of tiers to, you know, how significant of the protections you want to essentially have in place. And so I would say that kind of the starting point for protection is it's going to be, again, contracts, right? And so contracts in some variety or another. And, you know, one thing that I see people do, and I think is a really good practice to get in the habit of, is when you email someone something that you'd like to protect, and maybe you just make this part of your email signature, but you have that little confidentiality notice in the bottom of your email. And then essentially what that does, that's not technically considered an actual agreement. It's not a binding contract between you and them. However, it does put them on notice. It serves as legal notice to them that you consider this information or this material to be confidential. And then if they go out and they share it or they use it, you could try to come back and say, look, you were on notice that this is confidential, and by sharing it, you breached that confidentiality and there's liability. And so let's say, you know, maybe necessarily that wouldn't work, the enforcement wouldn't work. It's more about the deterrent, right? It's putting that confidentiality notice in there, and then they know not to use it, and then hopefully they don't. And so things like that, you know, putting those on the materials too, great way to protect yourself, kind of easy, low-hanging fruit. It's
like locks keep honest people honest. Like putting that disclosure is just, you know, going to remind people. Like you said, it might not hold up, but it'll certainly be a deterrent for some. So totally. I like that. Sam, you didn't, I need to do that on mine. I don't think I have that, darn it. Okay.
It's a good thing to have.
And you and I have been emailing back and forth. Where's that, Mary?
Well, emails to me, I'm not going to be like, hey, keep this confidential, because we're bound by confidentiality anyway. But another great way to do it, and this one, I kind of always give this one with a little bit of a grain of salt, because it won't always work. And so that is using an NDA, a non-disclosure agreement, confidentiality agreement type of situation. Because if you're pitching, or if you give materials to someone, you want to protect it, and they sign that, that is then a binding contract, and that is enforceable. Now, that one's a little bit difficult sometimes, because if you're pitching, let's say, to an accelerator or something like that, or you're pitching to an investor, they get pitched to all the time. And by pitching to them and having them sign something like that, they're actually basically just inviting litigation. Because if they then get another pitch from someone else and it's somewhat similar to yours, and they pick that one up but not yours, there's a chance that then you're going to, as the one that had them sign that, you're going to sue them. And if you sue them, it could totally be innocent that the other idea they picked up was just similar and wasn't your idea. But if they sign that NDA, they're opening themselves up to getting sued for, you know, optioning other ideas or investing in other companies. And so an NDA is a little bit of a steep kind of hill to climb sometimes with folks. So that, you know, message in your email, if you put it on a pitch deck or any of your materials, that's always a great thing to do. And then, of course, you know, registering a copyright, registering a trademark, those are sort of like the top tier, you know, the cream of the crop way to protect all of your intellectual property. But, you know, I think it was, you said David's question, it's tough because you have to balance, you know, cost versus the ROI. And, you know, what we always do is we run a trademark search first for trademarks, brand names. Yep, you went through that process, and hopefully you thought it was a good process.
It was painless, and the price point was totally worth it. I have to say, I went through it before, and it was more expensive, and yeah, it didn't work out right. Like this one, it worked out right. It wasn't, thousands of dollars to see if I could even, trademark or copyright something. So the process was great, you guys. If you're launching your business or you have your business and you're thinking, I should start protecting myself, I always do this wrong. Sam's your guy. So David, Colleen, Melissa, Sam's your guy to get started. Don't wait. Do it now. That's my advice.
In the search, and that's a great recommendation for the search, even if you just do the search, because the search alone will give you all the information that you need. And when we run the search, we ask you to tell us sort of like all of the products and services that you ever plan to offer, ever, because then we can look ahead and say, okay, well, are we going to be in danger if we file in the class for merchandise or for online classes or whatever?
So how many so I didn't know this, and I want to make sure our audience knows, Sam, you don't just file a trademark or whatever in one category normally. How many categories are there?
There's actually 45 separate classes or categories of trademark. Yep.
And we figured out for myself, right, that I would be in 3, I think it was.
No, I don't think it would have been 3. It probably would have been 41 would have been one of the ones we searched for you. 35 might have been another one that we searched for you.
There were a couple, but I wouldn't have known that, right? And I know when I went through this process before, like none of that information was shared with me. I didn't know that there were 41 categories, and I need to determine which categories would I possibly fit into. And also I didn't get that detailed report that you sent me. I was like, what? That was amazing. So you have to understand that there's more than just one category. It's a little more complicated. So I want to make sure we get to this question on the screen.
Sure.
Melissa, are a business name and a business logo 2 separate trademarks? Hit it, Sam.
They can be. So, and this is another situation where the 45 different classes come into play, because there's a lot of strategy that actually goes into trademark. It was a great point you made. It's not just, file it and that's it, because there's also situations where if you file a trademark application, you can be inviting a cease and desist letter if somebody else out there has an identical or similar brand. So yes, sometimes the name and the logo can be separate trademarks. What I always say to that though is, let's say you have your name and then your logo is like a stylized version of the name, like in, a different font, or maybe it's in like a circle shape or something like that. If your logo is only a stylized version of your brand name, then it's going to be the same trademark. And the reason for that is that with trademark applications and registrations, if you file a word mark registration, so the other one would be a logo mark, but if you file a word mark application and you actually register, the words, whatever they are in that word mark, are actually protected in every font, style, color, orientation, shape, size, whatever the case. So if your logo then is just a stylized version of the words, I wouldn't recommend doing the logo unless it has some, unique graphical element that you're really tied to, which, great point at the beginning of this call about the cupcake, teal logo that we were talking about, because logos and brand names aren't just logos and brand names to most people. They're very much emotional and very much important.
I was very emotionally attached to the LinkedIn bakery as it honored my mom, who passed from early onset Alzheimer's. She's the whole reason I started my business. She was an amazing baker that everybody would like. People would say, Nancy, can you make me a cake? They would pay her to make cakes and cookies and breads. And it's one of the talents that I inherited from my mom. So like I have that personal connection. And the person that actually did this knew my whole story, knew my journey with my mom and how personal the LinkedIn bakery was.
It's tough when that happens too, because, I like to try to give people the benefit of the doubt and say that they don't know better. Because sometimes they don't, in reality, some people don't know about trademark. They don't know that you can't.
I don't think she knew, but she took down the website.
That's good.
Yeah. People like, do you know that so-and-so copied this? And I was like, what? And I was like, oh, I went through every emotion. I was like, F-bombs were, I was like pissed in my living room. My husband came home. I'm like, oh my God. And then I was crying. Like it was very emotional. And so, by having this show, I don't want any of you to go through that emotional trauma that I had to go through. Get your assets protected.
Yeah, and that, you actually offered a really good example of what trademark law is actually designed to prevent, which is consumer confusion. So if somebody calls you, like anybody listening to this, if somebody calls you, emails you, sends you a social media post of another brand, and they're like, hey, is this you? Screenshot that, save it, because that's actual evidence of consumer confusion, which is, again, what trademark law is designed to protect against. So that is evidence of infringement and is actually something that you could use to support your case that someone's infringing on your trademark.
Consumer confusion. Okay. Whew, gosh, so we could probably talk for hours.
I actually had a guy once.
Yeah.
Yeah, right. I was going to say I had a guy once, though, real quick. He came to me and he said, there is nothing on the metaphysical plane that will make me rebrand. I want this trademark. And we ran the search and it was not good chances. He was going to get himself in trouble and he ended up changing it. So apparently the only thing on the metaphysical plane that got him to change it was a search report.
Oh, interesting. I think it's totally worth the investment. It's not thousands of dollars to do. What do you call it? The search, the copyright search. Like it's totally worth it. Trademark search. Everybody that's watching this, if you haven't had it done, you need to do it. If you're thinking of launching a business, you need to do it. You need to contact Sam and go through that now to save yourself the headache and the trauma of building a business and a brand and a reputation, and then, get a cease and desist letter or find out you can't trademark that as you want to grow. I do know someone in San Diego who had, and she won't mind me, I won't say her name, but I know she won't mind me sharing the story. She had the chocolate festival. Okay. It was the chocolate festival was down at, like the harbor somewhere, and they're like Liberty Station. It was down at Liberty Station, and they had like a bus. They had the design on a bus bench. I think they had a billboard. Like she went big. Willy Wonka had trademarked like the font that she used. They got an cease and desist letter.
Yeah,
I mean, we're talking. She paid a lot of money. We're talking billboards, bus benches and stuff, and all the graphics, the word chocolate, it was the same font, right? Something like that. Does that make sense? It was like that font, and she got cease and desist and had to change everything. Yeah.
So and what's interesting too is I and you know this from working with me, I try to really I want to hear the circumstances, the facts, the situation, and then I want to help you navigate through that in the best way for you. And so sometimes what we actually recommend to people is, okay, look, definitely don't apply. Don't apply to register this trademark. However, if your understanding of the risks of continuing to use it, knowing that there's other similar marks out there, then you can do that knowing that maybe someday you will receive that cease and desist and you'll have to change your brand. And there's really, two schools of thought on that. There's the one that I subscribe to, which is just don't do that and change the brand right now, so you're going to have to deal with that later. But then there are some circumstances, I think, where I actually could lean towards this other school of thought, which is, it's the ask for forgiveness later approach. Get out there, do it, make the money, and then when they hit you up and say, hey, you got to rebrand, well, at least you have the money to rebrand because you already got out there and did it.
It's just a headache. I just went through the rebrand, as you know. So I'm telling everyone, don't go. For me personally, I'd be like, no, because you don't want to have to. That rebrand is difficult. I'm still finding things that need to be changed. So we have another question here. I love this. Melissa asks, do you recommend trademarking a tagline? Again, Melissa, you do not know how spot on this is, because I worked with Sam on this because I wanted to trademark my tagline, connect, cultivate, convert. And Sam, you can use me as an example that I opted not to because I was probably going to get the.
Yeah, we try not to, be so scolding of people, but I feel like we do a good job of doing it in a way where it still comes across that way, which is important because we have to kind of navigate, like I said. And yeah, I mean, I think that's a great example of a situation that I mentioned before where sometimes you just don't need to apply because maybe there's a lot of marks. And this highlights something. I promise I'll get to the tagline question, and the short answer is yes. But what you can do with trademark is that there's just a lot that kind of goes into that strategy once you run the search, because with the trademark standards, there's the USPTO and then there's the marketplace. And so what I mean by that is that when you apply to the USPTO, they have to have the most narrow, stringent standard for what can register because they're the ones in charge of what registers. And so they're going to inherently then have a stricter set of guidelines and sort of thresholds for what can register. And so for the search report Mary just mentioned, we looked at that and there wasn't anything necessarily identical to that already registered, but there were things that were close enough that my expectation would be that the USPTO would refuse it. And so then why spend, close to $1,000 or more to then get refused, which is where the value of that search comes in, because it helps us build then that strategy for the application. And so kind of moving into the tagline, that's an example of the way it went for her on her tagline. But taglines are certainly something that you can get registered because they are similarly like a trademark that I mentioned before, like a Nike swoosh, but just do it. That's their tagline, and that's a very much trademark registered all over the world type thing because it's still a source identifier.
Yeah.
So when you think about that, like, the Chanel number 5, where what that is, where it comes from when you smell it.
Yeah, you don't have to say the product. If you just say Chanel number 5, it's not shoes, it's not a purse, it's not a hairstyle, it's perfume.
Totally. Yep. And that's
you don't have to say, you don't have to say Chanel number 5, the perfume.
Right. Exactly. And so it's great because you could probably even say number 5 in some context and they'd be like, oh yeah, Chanel number 5. Because then it automatically signals to the hearer, the reader, whatever, the viewer, like where that comes from. And that's a trademark. It tells you the source of those products or services. And so a tagline certainly can do that. Hashtags can even do that. We've looked at registering hashtags for people.
Oh, can you register a hashtag?
You can. It's a little bit tricky, but you
Wouldn't
can.
Wouldn't it be hard? I mean, well, okay. If you started a personal hashtag, right? Let's say you just started a personal hashtag and there's 5 followers. Do you have a better chance of registering that? I'm just asking, like, probably. Oh, wait a minute. What is this? I could maybe register my hashtag?
Maybe. Yeah. I mean, sometimes though, like the thing that I'll see sometimes with folks is they'll come to me and they'll be like, hey, I want to register this trademark or this hashtag or this tagline, and it's their name, And so like if the hashtag you're talking about is some version of your name, you can probably register it, but the value in doing that, I don't know if that's there because it's very unlikely.
It does have part of my name in it.
Okay.
So we came up with 2 new hashtags for me because it's all about branding, right? So someone came up with Mary on the Move because they're like, you're always like learning, going places. I'm like, oh, I like that because I can use that for my personal posts when I'm hiking and kayaking. And then someone else came up with Grow with Mary because what I want people to do, I want them to grow. But then we're starting a new show next week because one show isn't enough. So we're starting 15 minutes with fame. So or 15 minutes of fame. So instead of fame, because my Mary Fame brand, so the fame isn't, So that's going to be my hashtag, 15 minutes of fame.
So I think you could probably do Grow with Mary and 15 minutes of fame. Those would probably work. The Mary on the Move one might be a little bit harder because, and this is a great segue. It's almost like, we set this up. But the thing that you have to do for the USPTO is you have to show them trademark want to apply to register with the products and services, which sounds easier than it actually is, unfortunately, because when it comes to like products, it's a little bit easier because usually what you can do is, as long as on the website, the logo and then also a purchase button, the functionality to actually purchase the good, as long as those 2 are visible together, then that's really easy to show the USPTO that logo or trademark is used with those goods. You could also put a hang tag on it, like when you receive a product and it's got the little tag hanging off of it. If the logo's on there and we snap a photo of that for the USPTO, that's a great way to do it. Services, though, tend to be more difficult. So like, that new show that you're doing, if the title slide has, 15 minutes of fame or with fame, I forgot which one you said, and then maybe like a short description of what the actual episode is like or about or for, that title slide would be what we would submit to the USPTO because then it would show the mark and what it's for.
We have a graphic that was made by my designer just for that. And it has the name of the show. And I'm not going to say yet. You guys have to tune in next Wednesday. I don't know what time. With what the show's about and who it's for.
Perfect.
Interesting. I just thought I like to throw out those real life examples, right? So that people can really relate. So that's interesting that you could actually hashtag or trademark, and it's all fascinating. I'm just like, so much to go over, Sam. So much to go over here. Wow. Oh.
Area of practice all rolled into one.
Yeah. Lots of info. So I shared your, people wanted your website, your email. So I shared all of that in the comments. But Sam, I want to make sure that you go back in after the show, answer any of those questions maybe we didn't get to, because we're actually over time and we're not done. Because today has been so great. So many nuggets, you guys. And I know someone said in the comments that they want to contact you about trademarking their logo or something. So they'll be contacting you. It might have been Colleen. Yes, they need help with their trademark. So you've got a couple people that might reach out to you. Just don't forget, I take 10%. Just kidding.
You know what sucks is I would be happy. Like I'm a rising tide lifts all ships, but we're actually not allowed as lawyers to share fees. It's kind of, it sucks.
Sucks. That's okay. You can buy me coffee when I'm in San Diego.
Perfect. Or kayaking. You can get that going. I'm going on a kayak camping trip like 2 weekends from now.
I'm hoping to be in San Diego in August. So my husband, who works for Amazon, they're looking for some people to go from here to train the new associates for the new Amazon in San Diego that's opening, ironically. And he would be in San Diego for 3 weeks.
Cool. I'll be gone probably like 1 or 2 weeks of August, but hopefully it'll line up that I'm here while you're here.
Yeah. Okay, this has been such a great show. So many golden nuggets. Viveka, you joined us. Yay. So Viveka, no sharing with non-lawyers. So Viveka's, what do you call yourself, Viveka? A recovering lawyer or recovering attorney? She teaches LinkedIn for attorneys. So we collaborate together. We're both LinkedIn experts, trainers, and speakers, but we refer business to each other. Nice. So she has a very, very niche. Right. So when a client comes to me and they're an attorney or lawyer, I could do the work, but why not give it to her when she knows the lingo inside and out? So thank you, Viveka, for joining us. So we have one more question. Do you have 5 more minutes?
Yeah, absolutely. It's the one about the multiple different.
Yeah, you saw that.
Yeah.
Yeah. Do you see business owners copywriting or trademarking multiple items and taglines for several different aspects of a single business? Sam, that's all for you.
Yeah, totally. So, kind of going back to how I said I like to practice as an attorney, it's one of those things where I'm going to give you all the information, my perspective, my opinions, the law, and then it's really up to the client to sort of prioritize what they think is most important to protect and if they want to protect it. And so certainly I have clients that have, a portfolio of trademarks that's dozens of trademarks that we filed for them. And they may be for all similar verticals in their business, separate ones. There's really no sort of like restriction on how many you can have. And that's just trademark. You can have many, many trademarks for a business. Maybe every time you roll out a new product line or a new vertical, you get a new trademark. That's certainly something, that I see done. Kind of like we're talking about with, you're gonna have new shows, maybe you'll have new trademarks. But then also with copyright, that's something that you usually would have a lot of those, right? Because copyright can be, if you go back to like the Harry Potter stuff, she's probably got dozens of copyrights for all of the different types of materials that she's come up with in the Harry Potter world. And so copyright is also the cheapest intellectual property filing fees. It's like $30 to $55 per application, whereas trademarks usually $350 per class, like we were talking about. And so, with copyright, you could have, several different workshops copyrighted, several different types of
training. Different trainings. Yeah. So a lot of people in the service world, we have trainings and we want that copyrighted because like when I go on, let's say right now, Zoom, right? I'm doing a Zoom presentation and they want to download, they want to have my presentation available. And I'm like, for 30 days. Because if someone misses, like I had a talk with like 200 people registered online and not everyone's going to show up. So I said, you can have it for 30 days, but that's a good point. So I know there's a lot of service providers in my groups and in my network. So copywriting your presentations is probably something really, really important and that we need to look into.
Totally. And then this other question on how do you protect website copy. So there are certain times where I am going to kind of cut against the grain of what lawyers typically would recommend, because to the point we were talking about with the connect, cultivate, and convert, like ultimately I said, don't register that, which means I'm not getting paid to file the application for you.
That's why I love you. You give it to us straight.
Yeah, because a lot of attorneys, you're going to come in the door and they're going to be like, yep, do it. I'll charge you for it. Let's go. And that's just not how we want to operate. And so with the website copy question, usually what I say is like, you can certainly file a copyright application to cover the copy on your website. It would be some version of a literature type copyright registration. But what I would say to that is, one, copyright content on websites changes so much that once you copyright it in a certain format, if you change it a little bit, it might fall outside of the copyright protection. And then number two is just the fact that because it is that easy for it to fall outside of copyright protection, it's probably not worth spending the money on the copyright application to protect your website copy, unless you don't plan to change it very much or people are actually copying it. But keep in mind that there are some like informal kind of mechanisms that you can use when people are using your content, especially when it's copyright. It's called the DMCA takedown notice, and the DMCA stands for Digital Millennium Copyright Act. And that actually is a mechanism on any platform. So even StreamYard, like if we went to their privacy policy or their terms of service, they would most likely have an email or a form you can submit where you can claim that somebody's using your copyrighted material without your permission, and they'll automatically take that down, they being the host of whatever platform it is. So that's like Facebook, Etsy, Pinterest, whatever, and they'll take it right down. Now, the people that got their content taken down can come back and say, look, they're wrong. I have permission to use this. And it'll go right back up. But you've sent a shot across the bow. You made them know that you're serious. And then you can start the conversation of, well, what you have is infringing. And by putting it back up, you're now intentionally infringing. So if I chose to sue you, it's a big deal. You should take it down.
I love it. This has been so amazing. I try to keep my shows to 35 minutes. But literally, we're way over because there's so much great information that we need to be sharing. So thank you, Sam. I think that you froze up, but I'm hoping that you come back. Let's take this off. Sam.
Am I back?
You're back. Yay! Gotta love technology. I just always give it a minute or two. So are you ready for my rapid fire game?
Sure, let's do it.
Okay, so I'm going to give you 2 words. You have to choose one. You can't say both, and you can't add your own answer. I promise not to embarrass you. This is just so that we all get to know you a little better, and we end the show on a fun note. Cool. So, flip-flops or boots?
Flip-flops.
Right. Pizza or tacos?
Pizza.
Country or rock and roll music?
Rock and roll.
Beach or mountains?
Mountains.
Oh, baseball or football?
Baseball.
Mini golf or real golf?
Mini golf.
Laptop or desktop?
Laptop.
Podcast or video?
Ooh, video.
Cat or dog?
Dog, for sure.
Okay. Thank you so much for playing. Thank you so much for coming. Melissa said, this was awesome. Can you post Sam's contact information? Yeah, we'll go back on and post that again. It's a couple times in the comments here, and I know it can be confusing to find, but we'll go back on. Sam, as always, thank you. When I get to San Diego, we are totally going to meet up in person and take a photo. We're going to have a beer and some, you said pizza, so we're going to do beer. I should put on here, and I think I had it and I took it off because I did have like wine or whiskey. Like, so are you a wine or whiskey guy?
I would go with whiskey on that one.
We're going to meet up for whiskey when I come to San Diego.
Perfect. Even better. I always tell people I'm an old man. I'd rather have a scotch and sit on a chair on a Friday night than be out at a party or something.
Me too. Like, give me a good conversation with a nice whiskey. Now, I do like some live music in the background, though.
True. I've been going to Panama 66 here lately because it's the only place I can really find to be outside and get live music.
Nice. Okay, this has been another episode of Bite-Sized Tips for Busy Entrepreneurs. I hope that you'll join me next Wednesday when I launch my new show, 15 Minutes of Fame. I don't know what time, but I'll be announcing that on Monday. It'll be quick and short to the point, full of thoughts, tips, and trends to help you stay focused on your LinkedIn game.